3 tips for a rock solid settlement agreement with that nasty client this week on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. My name is Rob. I will be your host. We are going to be talking about settling disputes, nasty disputes, disagreements, fisticuffs with terrible clients, how we do that, and what we're looking for in the document that the client signs in order for everybody to go their separate ways. But before we get into it, please go to Wedding Industry Law on YouTube, subscribe there, maybe leave a comment. You don't have to leave a comment, but you do have to subscribe. Again, YouTube has a lot more content than just this podcast, so stick around, browse some videos, but you don't have to, but you do have to subscribe. That's my only call to action. Right now, I have maybe 200 subscribers. I'm really looking to grow that. I'm not trying to be the next influencer. I'm just trying to build up to 1,000 because that is the threshold for going live with your mobile phone on YouTube. So please do that. I'll be your best friend. On with the content. So last week, I should say, we talked about cancellation agreements. In other words, the document that is signed when the parties love each other but still want to terminate the contract. When you got a client that just wants to leave, and it's not because you did a poor job or there's a dispute of whether or not you did a good job. It's just an amicable split. This week, what I'm calling a settlement agreement is the document that is signed where it's you know that thing they do like the weekend before a big heavyweight fight where the fighters get weighed in and like they take the picture where they got their fists in each other's faces and it often breaks off into its own fight. That's when the settlement agreement is signed, is when you're about to file a lawsuit against somebody where it's very, I don't know, there's a lot of animosity, okay? The reason why these two documents are different is because contracts, all right, have limited real estate. In other words, you don't want to waste space. So there are things that are going to go into a settlement agreement that don't necessarily need to be in a cancellation agreement. I hope that makes sense. So the point of today is to talk about the things that you want in a rock solid settlement agreement when you and the client are PO'd each other and you want to go your separate ways, how to protect yourself in that instance. Okay, we're not talking about amicable. We're talking about the client wants your head. So what is critical in a settlement agreement? The number one thing that is critical in a settlement agreement is release of claims. A release of claims. A release of claims means that the parties are agreeing not to sue one another or to essentially waive their right to sue one another for a host of claims. And what a claim means is breach of contract, negligence, defamation, intentional infliction of emotional distress, anything. You ate, the last of the Cookie Crisp. Doesn't matter. That is the primary function of that settlement agreement, is essentially the concept of a covenant not to sue, which technically, if you're a lawyer, I understand there's two different things, is release from a covenant to sue, but I consider them the same thing. You're promising not to sue one another over anything. That's the important part of this, is that you want to make sure that it encompasses all claims from the beginning of time when there were dinosaurs to today. All right? So that is the primary function, and you want to make sure that your settlement agreement that you're getting into has that covered. A release of claims and or a covenant not to sue. I like the covenant not to sue depending on whatever jurisdiction you're in, is because you can get If they file suit against you, even though they file the settlement agreement with a covenant not to sue, you get an entirely different set of damages that you might not be able to get if it's just a release. But that's just something for the lawyers out there. Anyway, covenant not to sue / release, number one thing. The number two thing is non-disparagement. Your settlement agreement, because this is a contentious time in the relationship between you and this client, you want to obligate that the client will not disparage you. Now, remember that everybody is free to do whatever they want to do in life, typically, unless there is a contract that says otherwise. So if you don't put non-disparagement in this contract, then they have the right to do it. And to be fair, and as I've explained in another episode, you can go find it. I don't remember. I'm not good at remembering episode numbers, but there's not so many episodes that you can't find the one that's about defamation. But disparagement is different than defamation. No one can ever defame you. No one can ever defame you. That's an altogether different animal than disparagement. So your settlement agreement needs to obligate the other party to neither directly, meaning they don't disparage you online or on paper or at the hair salon, nor indirectly, meaning they direct someone else to do it for them. They will not disparage you. Does that make sense? If you don't put that in your contract, then they're not obligated not to do that. So release of claims, non-disparagement. The next thing is confidentiality. Not necessarily confidentiality to the events that took place that required a settlement agreement, okay? Like he said that she said that he messed up and you should have been over there. Not confidentiality in terms of that, although some settlement agreements do have that. I feel like that's a harder thing to do. It's harder to make someone say, I will never mention this again, like Voldemort, right? That's hard. The confidentiality that I'm talking about here is the confidentiality as to the terms of this agreement. In other words, well, I can't disparage ABC wedding vendor, but I got paid money so that I wouldn't. They can't do that. They have to keep confidential the terms of this settlement agreement. That's an important thing. You're already paying for the non-disparagement. Why not just go ahead and pay and say, look, you don't discuss how much money is exchanging hands. Don't discuss the fact that we're entering into this thing. That's perfectly okay. And I think that is hand in hand with the non-disparagement. So again, release, non-disparagement, confidentiality. The last thing is this. It's enforcement. The enforcement mechanism of the settlement agreement. Again, I don't want to get super esoteric. I don't want this to become like a law school. But typically, when someone breaches a contract, the only remedy that you have in a court is money. So if someone did go online and disparage you after signing this settlement agreement, typically you would have only the right to sue and to try to tell the judge, well, they breached this contract. This is how much their disparagement meant, X, Y, Z. Or maybe they didn't keep confidential the terms of the settlement. You have to file a breach of contract, try to get damages for that. That concept is different than what we would call in the law equitable relief. And I believe that I've talked about this before on the podcast. I just don't remember what episode, but it's important here. You want the contract to provide a mechanism by which you can ask the court for equitable relief if they violate the non-disparagement or the confidentiality, meaning that you and the other party, the client, are agreeing to sidestep the law, to go around the law that says, I'm only going to be able to get money. Because at the end of the day, what you want this contract to do is allow you to go to the judge and go, money's not going to do me. I want that client to take down that review. That's the relief that I want. I want that client to stop going to the hair salon and talking bad about me. That's injunctive relief. And again, like I said, typically a judge is not going to give you that. The judge is only going to try to estimate how much money that's worth to you to make you whole. You want an enforcement mechanism built into that settlement contract to the best and to the fullest extent of the law that's going to allow a judge to direct the client to do something. I hope that's clear. I hope that makes sense, because most of the time that is not in settlement agreements, and you want to make sure that that is in yours, because sometimes money is not going to do you 2 or 3 years down the road after a breach of contract action, or maybe a defamation case, doesn't matter. But an emergency relief from a court directing somebody to take something down or directing somebody to stop doing something, and if they don't, they're going to be in contempt, that's super powerful, super powerful. And it requires specific wording. And depending on what jurisdiction you're in, requires a lot more specific wording. So that is definitely something that I would recommend that you think about in your settlement agreement: enforcement mechanisms, injunctive relief. The last thing I want to bring up, even though I only said there was going to be 4, is typically for there to be some type of settlement at all, there has to be consideration for it. And I don't want to get into what technically is consideration, but your settlement agreement needs to address what's being exchanged for the execution of this contract. So it might just simply be, I'm not going to have to show up and you're not going to have to pay me the rest of the contract of the original service contract. I don't know what it is, but whatever the case is, that needs to be explicitly laid out. What's the consideration for the settlement agreement? And make sure that is explicit within your settlement contract, your settlement agreement. So in other words, we have 4 things, possibly a 5th thing, that I would highly recommend that you think about for your settlement contract when there is a dispute: release of all claims / covenant not to sue, non-disparagement, obligating the parties not to disparage one another, confidentiality, meaning keep your trap shut about the terms of the agreement, and finally, providing your ability to seek equitable relief, non-monetary relief, enforcement. That's super important. And again, this is not to say that you don't have other things in your settlement agreement. There are important other terms. These are the terms that I think are most often neglected or not strong enough. So this is what you do in order to have a strong settlement agreement. I hope that you found the content of this episode super helpful. Contracts are my bag, and I enjoy talking about them. As you can see, if you're watching this on YouTube, I don't make cuts. Like, this is just off the top of my dome because I do this stuff and it's super fun to me. At any rate, if you like it, like and subscribe. Tell your friends. Hit me up on Instagram. And with that, we'll see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.